We're welcome to Financial and Estate Literacy. It's your estate. This is our fourth session, I believe, on wills and trust. Our speaker or our presenter to our third week. This is our third week. Thank you, Don.
That's okay.
Our speaker today is.
And I'm going to go away and I'm going to watch the Q&A and answer questions as I can, and we'll be back later on. Bye.
Okay. See you later, Don. Don't go away too far. Stephen is going to be our presenter today. So we're going to kind of summarize kind of his Ask First form, which, by the way, is online. So you can go to IYME to get the outline today and also to get his Ask First form. Steve, you're a graduate of Western State University. How many years practice have you been in the estate planning area?
Since 2014.
2014.
9 years. Yeah.
And you are what's called a certified specialist. What does that mean?
That means that I had to take on a number of different cases in trust, probate, and estate planning, as well as taking an additional bar exam-like test.
So
with the state
why we talk about this, by the way, just for full disclosure, Steve is my go-to attorney in the estate planning area. But why would a consumer want to go to someone like you whose only area of practice is estate planning?
Well, unless you are very familiar with all the issues that come up in the trust and estate world, you may not necessarily be able to advise someone properly on what type of estate plan they need or what type of estate planning distribution scheme they want to set up, or the risks associated with whatever they have planned.
Yeah. Steve has told me many a time that he cleans up other attorneys' work. So you do litigation.
Yep.
You do. You have another partner who does family law. So those two things together sometimes are really advantageous. And then you also do administration of trust and probates. Do you handle conservatorships?
Yeah, we do. Anything related to probate is what we handle. Estate planning, trust and estate administration, conservatorships, guardianships.
One of the things that everyone is concerned with is, how do you charge? What are your fees?
So it varies on whatever we're doing. So estate planning is generally based flat fee. And if it is an administration like thing, sometimes it's flat fee, usually it's hourly. I'm at $400 an hour and our paralegals range from $150 to $175.
I'm married. I have approximately $1 million estate. I have one beneficiary. I have one property. What would be the fee to have you draft the will, the advanced healthcare directive, the durable power of attorney, and the living trust for both of us?
For a married couple, it would just be that, which would include a deed and other documents, as well as it's a flat fee of $2,000.
$2,000. If I was single, what would it cost?
$1,600.
$1,600. Okay. Do you charge during this period of time? Can someone call you for additional questions? Would that be an extra charge, or would that be included?
No, that's usually included with it. Generally speaking, don't really have an issue with having multiple consultations, which usually comes up for estate planning.
Yeah. Is the initial consultation, do you charge for an initial phone call or initial consultation in the office?
Nope, we have free initial consultations.
Which, by the way, is very rare, because the only thing an attorney has is his time or her time. And for someone to give a freebie on their time is absolutely, I think, an awesome benefit to the community, because you just don't know. A lot of times we're going to be talking about wills and trust. Do you review other attorneys' trust? One. Two is that, do you administrate other individuals' attorneys' trust?
Yes to both. So a lot of times their attorney will retire or they'll move from out of state. We'll take a look at the trust and see if anything needs to be changed, but unless you're changing something substantively, usually you don't need to make a change.
Okay. All right. So let's bring up your outline and let's get started. We've got a good hour and 15 minutes.
Okay. Did that work?
Yeah.
Okay. All right. So we're going to be talking about wills, probates, trusts, and estates, and all the different issues that arise with having a will versus a trust. So if the first issue is whether or not you need a will, or what happens if you don't have a will. If you don't have a will, really the default rules under the probate code apply. And what that means is that you're gonna, if you need a formal probate proceeding, someone's going to be appointed as an administrator, and there's a whole order of priority as to who is entitled to serve over someone else. If you haven't changed the default distribution, the probate code has it set up that it goes to your heirs at law, and there's a whole statutory scheme devoted to that. And in certain cases, it may be people you had no idea would actually inherit, particularly if you have a predeceased spouse. And if you have a will, it allows you to choose who is going to administer your estate, and that person under the will is called the executor. It's the person you nominate in the will. And whether you have a will or not, if you have assets above a certain amount, you are going to need formal probate proceedings. So in either event, you're going to go through a probate if you only have a will and do not have a trust.
So most individuals have, what kind of a will do you usually call it, that most people that you prepare for a complete estate plan?
If they're doing a trust, they would still have a will typically included with the trust, and that's referred to as a pour over will.
And why would people need that? Why, if you got a trust, you avoid probate, so why would you have a will?
I always tell people it's really like the ultimate fallback. In the event that everything you tried to do to get assets into the trust, the will acts as the conduit to get it into the trust, whether it's through formal or informal probate proceedings.
So if, example, you mortgage, you refinance your house is titled in the name of the living trust. The mortgage company wants you to title it in your own name, and then they fund your mortgage, and then they hand the title back to you in your own name, and then it's up to you to retitle it back in the trust. And if you die during that period of time, you end up in probate.
Yeah, that's one scenario. Another one that we see more often these days is people receiving an inheritance and dying while it's pending, or actually never actually funding the trust at all.
Yeah, yeah.
Pretty common.
Title. Let's go to the next slide.
All right. So what a probate is it's really a court proceeding that's ongoing to ensure that you collect assets. One, that someone is appointed to administer the estate. Two, that person ultimately collects the assets, accounts for the assets, and then distributes the assets. Depending on the circumstances, the court involvement isn't as involved, but it's still required. So there's no way to escape it if you have assets over a certain value, which is, for personal property, it's $184,500. But
is the probate code the same in every state in the country?
No, it varies by state, and a few cases we've had, it becomes an issue because certain states will actually have different heirs at law in certain circumstances.
So every state controls its own real estate in that state, and you would have to, if you don't have a living trust, you would have to have some kind of a will, else you're going to go, or you have to have some sort of a trust to avoid probate in that state.
Yeah, if you have a trust and it's properly funded, you typically wouldn't need to open a probate in that state.
Okay.
But and that's if you have assets in different states, that's something you want to speak with an attorney in every state you have assets in to make sure there isn't anything you are missing, but also that your assets are properly titled.
So you wouldn't be able, for example, to probate a case in Texas.
Yeah, you have to be licensed. The attorney licenses are all state specific.
Okay, so it could cost you a lot of money if you have properties in other states and you don't have a living trust.
Yep.
Yep. Okay. Next slide.
So this is a breakdown of what the statutory fees are in a probate, should one ever be open for your estate. And it's quite a bit more. So it's in California, and this also again varies by state. In California, the percentages start at 4% and it's tiered down based on the assets in your estate. So if you have $1 million estate, the statutory fees for both the personal representative and the attorney for the personal representative have the exact same calculation, and the total fees you see there are about $46,000. So there's additional court costs of roughly $2,000 associated with that. So in comparison with a trust is maybe $10,000 to $15,000 to administer if you have $1 million estate. So you'd have quite a bit of savings if you had a trust versus going through the probate process, as well as the time involved in trust administration. It can be done much quicker than a probate administration.
What's the time period now in the Orange County court system for a probate?
It's 1 to 2 years, closer to 2 years for most estate administrations, only because the one year you have to wait for certain statutory deadlines, but there's also just the backlog in the court in general is an issue, but they're working on it. So far, it's still pretty lengthy, only because we do have a lot more probate filings every year.
Yeah, we had COVID, people left, the clerks left, people
Yep.
with experience, so they're rehiring new people. So the probate process has really slowed down here in Orange County lately. And it's expensive. So I'd like to always say, you know, you can pay me now or you can pay me later. What a difference in cost if you prepare an estate plan today. I just read an article that said that still the vast majority of people do not have an estate plan because of procrastination. Yeah, it's you need to get it done. I think this slide kind of tells you that it'll save you a ton of money and time, especially for your heirs. So let's go to the next slide.
So there's different ways of avoiding a probate, and a few of these ways are pay on death or transfer on death designations, and that is something usually attributed to bank accounts. And you can set those up. There's risks with those, and beneficiary designations is another. It's very similar to that. But what happens with those types of designations is that upon your death, the asset transfers to whoever is named as the beneficiary. And the risk of that is that the beneficiary does not survive you, or that there is some defect in the way you've designated this beneficiary in some way.
So a person could go to the bank and say to their teller, says, I would like to make this account a pay on death account. And they'll ask you for the name, you fill out a small form, and that's it. How soon after death can somebody access that account?
It's usually pretty quick. They need a death certificate, which is another issue that has come up recently, because you have to be, in California at least, you have to be a specific relation to the deceased person in order to get a death certificate. So if you are not friendly with family members, they may not provide you with the death certificate, and that could complicate you receiving an account like that.
Yeah, and beneficiary designations are usually IRAs, 401ks, insurance policies, annuities, those kinds of things. Do you review beneficiary designation forms during the estate planning process?
Yeah, if people have them. I don't know that everyone has them ready on hand, but yeah, it's something that I always tell people to make sure you check out at the very least and look at it, because oftentimes you set it up one time many years ago and never look at it again. And you may find that things have substantially changed.
Does a beneficiary designation trump a will, a trust, or any other title?
It doesn't really trump it so much as it bypasses them entirely. So a will and a trust would have nothing to do with something that passes by beneficiary designation.
Don,
But
you
with,
sound
with
like,
that, for example, if I have a bank or a credit union account, do you have to have a pay on death rather than a beneficiary statement? What would
It
be the
depends on
difference?
it depends on the financial institution. So a pay on death, there's specific codes that apply to them. Effectively, what they are is beneficiary designated accounts. There is some nuanced differences in the law on it, but as far as it goes, it just depends on the type of account as well.
Okay. And I'll ask, there's another question that I'll go ahead and ask now, and you may want to cover it later on. So my spouse doesn't agree with the fact of doing a trust. What's my option in terms of covering my half of the community property in terms of a trust or other things? And what do I need that uncooperative partner to do?
that's a great question. And as soon as we get to the revocable living trust, we'll discuss it.
Thank you. You got it.
Titling. Most people still have most of their real estate in joint tenancy. What's the problem with that? It avoids probate and,
Yeah, it avoids probate. There's a lot of issues with real property that we see when people put a child on as a joint tenant with them during their lifetime. One, the big issue with it is that you're giving away ownership rights of your property. There's also negative tax benefits to it because the cost basis that would pass to the child is only a partial step up as opposed to a full. The other big issue is that sometimes the child becomes non-cooperative later on, and they don't want to work with you to sell the property, or they for whatever reason believe that they are an owner and that they have rights to the property more so than just being on title.
so even married couples shouldn't use joint tenancy. What should, if they don't want, hey, I don't have enough assets to have a living trust, what should a married couple have their assets titled in?
They want it to be community property with right of survivorship.
Okay. And then talk about, what does step up mean?
That means that so your basis in the property is whatever you purchased it for, plus any improvements that you may have had. When someone passes away, so that's if you buy a house for 100,000 and it goes up to 500,000, you would get taxed on any gains above the additional $100,000 you purchased it for. If you when you pass away, you get a step up in that basis to the date of death value.
And therefore, if your cost basis is 500,000, your market value is 500,000, and you sell it for 500,000, no gain, no tax.
Yep.
So step up is huge. And if you have joint tenancy, you only get a half a step up in basis. Yes, Don.
You made a comment earlier in terms of death certificates, and if you are not a child, a bloodline relative, I think was the point of, you can't automatically get a death certificate. If they have a stepchild who is not adopted, can they get a death certificate? Or would they need to go through another family member, a bloodline family member, to get it? And their birth parents have passed away.
I don't know off the top of my head. I don't believe they would be able to, because I believe you do have to be an actual blood family member or a spouse.
But a spouse or bloodline could give them a death certificate that's still valid and can be used. It's a matter of having to go through the family to get it.
Yeah,
Okay,
and every single county is a little different. So in Orange County, they definitely want you to have some type of a relationship with the decedent.
Right. Okay. And just to, as long as we're here, let me ask the other question. A married couple should have their title not in joint tenancy. It's basically step up basis, first of all, because in joint tenancy it only goes up halfway, and in joint community property it goes up 100%. And there may be other issues in terms of what's going on. So
yeah, community property with right of survivorship.
There you go.
Yeah.
Or by the way, that's just in California. I don't believe other states have that. Is that true, Steve? Or
there's a certain number of states that are referred to as community property states.
Yeah.
So if you move to other states that are not community property, it's not going to make sense to them because they don't have community property.
Yeah, and it's
Yeah.
vice versa too. If you move here from another state, you should have your estate planning documents reviewed by a California attorney. So we're going to talk about a revocable living trust. And that is another way to hold title to assets. And if you own real estate or any type of assets, would this be the preferred way to hold title?
It generally is, because putting things into a revocable living trust will survive your death and allow you to control how things are distributed, because you can designate a successor trustee that can step aboard. And there's other concerns with it, because if you become incapacitated, that person could be acting as well. But the change of the beneficiary wouldn't generally occur until you pass away.
So it's almost like a contract that you make that that you put in. Talk a little bit more. Do you have a slide on revocable living trust? I don't know if you got another slide on that. Okay, yeah, there you go. Talk about this. Why is this important, by the way?
So what a trust is it's not an entity. It's a relationship between people and property. And so you have three categories of people. One is the grantor. Another name is a settlor, trustor, trust maker. That is the person who creates the trust. They don't necessarily have to fund it. Usually they are the people that fund the trust. There is also a trustee, and the trustee will be the person that manages the trust assets. The beneficiary is the person who receives the benefit of the assets being held in trust. So you can have multiple of any of those three categories. While you are alive, if you set up your own revocable living trust, you are the settlor, the trustee, and the beneficiary.
And if you become incompetent, what happens?
If you become incapacitated at some point, you are still a settlor. You would remain the beneficiary, but someone else would step aboard as trustee.
And that's isn't that one of the primary reasons why older individuals should definitely have a living trust?
Yeah, I mean, in that scenario, it helps reduce the likelihood that you may need a conservatorship. There's no way to eliminate that, because if you have a family that's going to fight, but what this does is it creates a vehicle by which your bills and things can still be paid.
So now let's get to the question we had before. My spouse doesn't believe in a living trust. I do. What do we do with our community property?
Well, it's more complicated than that. So you can give away your assets by will however you want, but you can't just take the assets away from your spouse if it's community property. You both have equal rights to the community property and management powers. So before you do anything in that regard, you should discuss it with an attorney, and it might even be helpful for and it's hard to say. I don't know how uncooperative the spouse is, but if they are willing to at least speak to an attorney, it might help explain the issues a little bit better. But if someone is uncooperative, you can't force someone to do something they don't want to do. So if you have assets jointly with someone, the short answer is anytime you hold something jointly with another person and you can't agree on what to do with it, you have to go to court.
Yeah, that's another thing too, is that when you're dealing with title to property, don't listen to a real estate agent. Don't listen to your neighbor. Steve has told me 100 times, come in and talk to me about what the situation is so I can give you a good answer based on the probate code and the case law today, because it changes all the time, right? I mean, that's the only way you stay on top of it.
Yeah, I mean, as a general premise, the probate code is fairly consistent, but there are a lot of nuanced things that change. And a lot of it, particularly as it relates to trust, it changes in a way to help people avoid having to go to court to get things resolved. And this kind of goes back to the issues with the courts being overbooked, is whatever you can do to avoid having to go to court, it's going to save you time and money, but also just the stress of having to deal with the court system.
Yeah.
So,
yeah. Let's go to the next slide.
So I think we covered what that is. Did you have anything to add on this, Pete?
Yeah, the only thing I've got to add is that on the successor trustees, how many should you name as successors in your document?
Really, you should name one successor trustee to serve alone. You can name multiple people. And then you would have 2 to 3 alternates as
In
well.
succession, or should they be
Serving in succession, not together.
Yeah, we just had a trust the other day that someone named 4 grandchildren in their 20s as co-trustee.
Yeah. Yeah,
A recipe for disaster, I believe.
Yeah, so the reason that that's not a good idea is what I mentioned earlier, is if you have a trustee, that's who owns the property, right? And
Or
so if you have
manages the
multiple
property.
owners, yeah, well, they hold title to things.
Yeah,
And so if you have multiple people that hold title and they don't agree, the answer is you're going to go to court. And so if you can avoid it, pick one person to serve, and that may not always be possible because of family relations, but in a perfect world, you should have one person with multiple successive people.
yeah. Now, there's 2 types of beneficiaries. One is an income beneficiary and one is a remainder. So the income beneficiary is usually the grantor. Is that correct?
Well, the grantor, if you're setting up your own trust, you're both the income and principal beneficiary. So you're,
Correct.
while it's revocable, you're the primary and the residual beneficiary.
And then once you die, the remainder beneficiaries are?
Whoever you name, you can name people to the residual beneficiaries are the people that receive whatever is left over, to the extent that your debts didn't require being paid off the full amount of what you had, and you didn't have specific gifts prior to that.
Okay, you mentioned there's 2 terms that you just mentioned that we need clarification on. One
Sure.
is, what is a specific beneficiary and what is a residual beneficiary?
So a specific gift, a beneficiary getting a specific gift is someone that's getting a specific dollar amount, a specific asset, something like that, something that is identifiable. A residual beneficiary is someone who's typically receiving some percentage of whatever remains after the specific gifts and debts have been paid off.
Should people in their trust do everything by, okay, I have $300,000 today. I want 30,000 to go to X. I want 50,000 to go to Y. I got, et cetera. Or should they do percentages from their residualist trust estate?
It really depends on what you want. So the distribution scheme under a trust is really whatever your imagination can come up with within the law.
Okay.
And what that means is it's much easier to do a residual beneficiary designation where people just get percentages. Because administratively it's easier. The more complex of a distribution scheme you have, the more costly and expensive the administration can be.
Yes. And so keep it simple, stupid, so everybody understands.
Are you saying that because I just came in? Thanks, Pete. Okay, so a couple of questions came up. This is your worst case scenario, I guess. If your trustee and all of the sequential trustees don't want to serve, what happens? Court?
Not necessarily. It depends on what your trust says. So some
Well, if you ran out of successors, is that why the last one you always put as a professional, a bank or a professional fiduciary?
It depends on what people want to set up. So all of those things kind of get gone over when you're discussing how you want to set up the estate plan. Okay. If you don't have any other successors, some trusts will set it up so that the beneficiaries can elect or appoint someone. Okay. Or they'll designate some other person to designate who a trustee can be.
Yeah. So
one question that sort of relates to one we had before. Are adopted children considered blood relatives? Legally adopted?
Yeah, if they're legally adopted. And a note on that, if you do have adopted children, you want to make sure you have the paperwork and things that can be referenced somewhere later. Okay. It's easier these days because there's more current records, but if you adopted someone many years ago, depending on where you adopted them, you just want to have the record so it can be substantiated later should there be disputes.
One last question, and it relates to titling that we've talked about. When in a marriage does property become community property? At the time of purchase?
So that's a bit more complicated.
Yes,
right?
it is.
Because it's not so much that it becomes, there's certain presumptions that apply. So anything you acquire during marriage is presumed to be community property. But there's also a separate property presumption. So if you acquire something from a separate property source, like inheritance, for example, then it's separate property. It's more complicated than a simple answer, I guess, is the short answer to that.
What the wonderful thing about Steve's office, though, is that Steve is a certified specialist in the estate planning area. His partner is a certified specialist in family law. So if there's a family law issue, he just walks across the hallway and gets an answer. and the family law and probate, there's a lot of issues that come to play because of death of a first spouse or second, third marriages, or children from the first marriage and children from the second marriage. So there are lots of issues that correlate, and incapacity is usually a triggering point. So let's talk a little bit about incapacity.
Before we do that, one more.
Okay.
So then property that came into the marriage from before the marriage. So I own a house, we get married, it doesn't automatically become community property. It's separate property because I brought it in. Can I make it? Can I declare it to be community property?
You can transmute the property is what the term is into community property, but that itself isn't the end of the story, right? So there may be a community property interest in that property. If you have a mortgage and you've been using community property, say the income you've made during marriage, to pay down that mortgage.
Same with property that came into the marriage. If you're paying property tax and mortgages on it, then you're using community property afterwards. So it's talk to an attorney.
Yeah.
Talk to your partner. Thank you.
Okay. Benefits of having a living trust.
So, the benefits of having a living trust really is that it's the big benefit for most people is to avoid the probate process by allowing the successor trustee to come aboard after your death, liquidate the assets, and distribute to the designated beneficiaries.
Or support the incapacitated individual, the grantor, if they can't manage the money themselves.
Yeah, if you're alive and you become incapacitated, which could mean a variety of things. It could mean dementia. It could mean a serious car accident,
stroke. To me, the living trust is literally about living. At death, yeah, you want things to go smooth, but you're going to be dead. So
it's someone else's problem.
Yeah, hopefully you keep your fingers crossed, and the family members are not going to cause a problem. But this is about you being alive. And the last thing you want to go through is a conservatorship.
Yep. Yeah, conservatorships are not fun. They're lengthy, expensive. And all of these things, nothing can ever guarantee you that a conservatorship won't be needed. I mean, there's people with full estate plans that still end up in a conservatorship. But what all of these documents on this slide really do is it helps minimize the likelihood that you may ever need a conservatorship.
Yes.
So it's similar to like insurance, but like a financial power of attorney, what that does is that designates an agent to manage your personal financial affairs. Completely separate from a trust. It doesn't have any effect on what the trustee's powers are. It may have an effect on what on the trust terms, because you can grant an agent the power to modify trust terms.
So
yeah.
In financial powers of attorney, when I'm acting as a fiduciary for someone, one of the first things I do is, how do you have title to that bank account? Do I put my successor trustee hat on, or do I put my durable power of attorney hat on? How you have title to assets determines what documents you use.
Yeah, definitely. Another big one where financial power of attorney comes into play is really when people have a reverse mortgage, because they will require you to have an agent if you no longer have capacity. Otherwise, they're going to require a conservator, and we've had that happen on a few cases.
Yeah.
So, there's an advanced healthcare directive, and that is like the alternative, that not an alternative, but a comparable to a financial power of attorney in the sense that you're appointing an agent. But under this document, it's appointing someone to make medical decisions for you in the event you're unable to. And the HIPAA authorization goes with that to allow, really, generally, it allows all of these agents to, if you authorize them, to find out confidential medical information about you to help better serve you under these documents.
And please discuss with your attorney who are you naming and go into some detail. This is not a, to be named as a successor agent under the financial power of attorney or in the medical care, the successor trustee is not about an honor. It's about having the ability to administrate for your benefit. So we're going to have a whole session on this in the last session, but just make sure that you need to speak to the attorney as to who might be competent and what kind of skills are needed, and your attorney will know that. And so discuss it with them personally. Let's go to the next slide.
So there's different types of trust. There's revocable or irrevocable. What that really means is that if it's irrevocable, once you've executed it, it can't change. If it's revocable, it can be changed. And sometimes if it's a little bit confusing because revocable trusts become irrevocable generally upon some condition in the future. So a revocable trust that you're setting up for yourself is revocable during your lifetime. Generally, it may become irrevocable during your lifetime if you become incapacitated, because effectively you can no longer change it unless you've designated someone else with the power to change it. Once you pass away, it would become irrevocable, and the distribution scheme at that time comes into effect. So upon your death, the beneficial interest in your trust changes however you would have set it up.
Do you normally in a trust give the children outright, or do you normally give their assets to the children in trust? And what is the benefit of doing one or the other?
So I don't really make the choice, right? It's the client making the choice on what they want to do. I generally steer people away from setting something in trust indefinitely for any beneficiaries, only because people think, hey, that sounds great. I'm going to save these assets for my kids until their retirement and they will be comfortable. What people don't realize is if you do that, there's cost of administration, which means a trustee compensation, attorney's fees, tax return every year. Those types of things, they aren't necessarily super expensive, but they are a cost to consider when setting it up. And the more assets you have, the more expensive it does get. So,
okay, let's go to the next slide.
Okay, the revocable trust, this just lists some of the benefits and drawbacks of it. Is that, I think we've covered most of these previously, but the big benefit of the trust is that it minimizes the costs for you, or it acts as a cost-saving mechanism in a lot of ways, both before and after death.
Yeah, incapacity is the biggest. Irrevocable, the drawbacks are, oh no, you're talking about the revocable trust. It's a little bit more expensive to set up, but wouldn't you let's say somebody just wants a will, a durable power of attorney, and the advanced healthcare directive. Wouldn't you have to go through almost the same process that you would have to go through to set up a living trust as well?
Yeah, generally the will isn't, for us, if you're setting up a will versus a trust, the cost isn't significantly different.
Yeah.
But the problem with a will is, one, if you're going to change a will, generally you're not just doing a codicil, which is the equivalent of like an amendment to a will. What you're doing is you really should just set up a whole new will each time you're changing it. With a trust, it's easier to do, but with a will, you also have formalities to the execution of it.
You put on here common fallacies. Touch on that.
So if you have a revocable trust, it doesn't provide you with asset protection. A lot of people think that it does. There's specific types of trust for asset protection that are irrevocable. The theory behind it being an asset protection mechanism is that you are giving up ownership in that asset. So that's why they cannot collect it from you, is because you are not the complete owner of it. With the revocable trust, you're still the owner of everything. You're in control of all of it. And you do not need a separate tax ID number while your trust is revocable.
Yeah, so you just use your social security number and you don't have to fill out a separate tax return for your trust. It's just an individual tax return. Let's go to the next slide.
Funding the trust. So this one is important to remember if you do have a trust or if you ever set it up, because you will hear a lot of things from your attorney and not a lot of it's going to make sense right away. It may never make sense. But the important thing to know once you've got a trust is that you have to change title to any assets that have title. So, and not just at the outset, if you acquire new assets later, you want to make sure you properly title them. And the way things are generally titled is in the trustee's name as trustee of whatever the formal trust name with a reference to the trust date.
He's back.
Welcome back.
So since we talked about it a little bit before in terms of the complexity of multiple states. So if I title something that is out of state into my trust, when I die and it's being administered, is there any problems that I would have with the other state?
Generally, it shouldn't be an issue because portability is allows these trusts to be used in all the different states.
So it should be titled just like a California asset would be, other than it happens to be in another state, but then you have to notify that state that you've re-recorded it.
Yeah, what you should do is speak with an attorney in that state or someone in that state that's licensed to assist you with title. Okay. That doesn't necessarily mean an attorney, but you want to make sure the title to that property was properly changed.
Oh my God, wait, what? I was supposed to talk to a realtor?
No.
Let's go, Pete, go ahead. I'm sorry. I know, an attorney is best.
Titling is so important. You can't emphasize this enough. But so how do people know whether or not, how can you find out if my title is correct? Where do you go?
Well, you can go to the county recorder's office to pull the deed, but really what you should do is, because the difficulty, we run into this a lot, is the county recorder, they're not licensed attorneys, they're not title, they don't give you title reports. Yeah, they're giving you a deed. And usually it's a deed connected to whoever's paying the taxes. So it may not necessarily be properly titled. If you go to attorneys, most of us have programs, I think, I don't know, I know we do, that we can pull the deeds up on the property. And some, rarely do you have issues where there may be title disputes. If there are, you do want to get like preliminary title reports and make sure that things are titled. And that comes up a lot of times with inherited property among family members.
Can a consumer talk, and let's say they own a home, call their homeowner's insurance insurance provider? Would they have, would that be a reliable source for title?
No, I'm not even sure why they would know.
Okay.
Because I mean, aside from seeing a deed at some point, they wouldn't follow the title.
And even if you had a grant deed, how do you know that's the last grant deed?
Well, you don't. You have to do a grantor grantee index search, which is a bit antiquated, and they're trying to change that. They have been for quite a while, but that seems to be the easiest way still of locating title.
Yeah, this is a good time just to remind everybody, if you can put all your assets in a column, next to it, put title, next to it, put cost basis, and then the last column, do market value. That would help an attorney or financial advisor, even a CPA, immensely, because it'll give you a good picture of your net worth and your financial health.
Mhm.
Does that ever happen, Steve, when somebody knows exactly how they
I've had some people, I mean, no, and that's the problem, right? Is we're not really trained to do that.
yeah,
But it is so important to have that information, because it makes sense in terms of estate planning, financial decisions as well. But a lot of people don't have all that information. People know they purchased a house for X amount 40 years ago, but they have no idea how much they spent on improvements over the years.
yeah.
You know,
Especially if you got a successor trustee stepping in because you just had a stroke, and
Yep.
they have to know all this stuff in order to manage your assets.
yeah, and all that stuff makes a big difference as well in terms of what assets people like you, Pete, have to decide what to sell, right?
Yeah.
Because if the basis on something is going to be very low, you probably don't want to sell it.
So
But
if the more assets you have some responsibility. If you don't have a lot of assets, go, hallelujah, I don't have to worry about this stuff. Next slide.
So real property, timeshares, and co-ops. So real property is real estate. The title is reflected with a deed in some way. This is common with in most single family homes, rental properties, commercial properties, and condos. The stock cooperatives are similar to condos.
But before you go to the timeshares, what is the definition of difference between a joint tenancy and tenants in common?
Oh, so joint tenancy has a right of survivorship aspect to it. And what that means is when the other owner dies, their ownership interest effectively disappears, and the surviving joint tenant or joint tenants are the owners equally of that property. Tenants in common, if you are tenants in common with someone and you die, your ownership survives your death. And that is something that may trigger a probate, may go past through your trust, but your ownership interest would survive. So
it doesn't automatically transfers to the other surviving tenant.
Yeah.
Okay.
With joint ownership, there's some minor administration to that, but yeah, effectively the ownership interest as of date of death is gone.
And what happens with timeshares?
Timeshares are never fun to deal with. So if you have them, you should just you should figure out how you even hold title to it. But two, it's much easier to deal with if you have dealt with it and gotten rid of it during your lifetime. Because every case we have that involves timeshares is just it's expensive and it's difficult to deal with, and it's also just difficult to liquidate.
Yeah. People try to get, when I was working with the American Red Cross, and people would try to donate a timeshare, we wouldn't take it because the expense of owning that on an annual basis, and there's in many cases there isn't a secondary market.
Yeah. Yep.
Out of state real property, we talked a little bit about that, and I don't but what does an ancillary probate mean?
So ancillary probate is a probate that's opened in a state that is not the state that you passed away in. So you could pass away in another state, and if you had assets here in California, you may have an ancillary probate open. And those could end in one of two ways. It can either be transferred to the other probate proceeding that is opened if there is one, or it can be distributed outright to the beneficiaries under your estate in California or whatever state it's opened in.
So, and stock cooperatives, you're talking more like Laguna Woods, Seal Beach, Leisure World, and those types of situations. Talk a little bit about that.
Yeah, so stock cooperative units, the transfer on those is important, or the ownership of it is important to understand. What you own is a stock certificate and a corporation, and that gives you a right to reside wherever you are living, whatever your address is. And if you have a stock cooperative unit, there's very specific rules that restrict how you can transfer title. So a big issue people always run into that I hear over here is that they want to put it out, their home in the trust, but they have a mortgage on it. If you have, and I think there's only one bank, National Cooperative Bank, that handles it. They have a security interest in holding on to the original certificate. Because they've got that original certificate, you can't transfer or change the ownership of it without going through them, which means if you want to put it in your trust, you either need to pay off the mortgage, or you need to refinance. So that's a big one. If you are thinking about moving to a place that has cooperative units, you want to set up a trust before you get there so that you have a trust to take title in when you purchase it. Because if you don't, it could complicate things in terms of administration later.
And again, this is a really important to know because, and you need to go to an attorney who's familiar with this process. If somebody doesn't understand stock cooperatives or timeshares, doesn't deal with these things on a regular basis, it leads into trouble. So Steve is proud to say that he cleans up a lot of other attorney messes. So in his practice. Let's go to the next slide.
So bank and brokerage accounts, you want to make sure that title is in your name as trustee of all of these accounts. And this does not include retirement accounts or 401ks. These types of accounts, if you have POD or transfer on death or beneficiary designations, you can, if your intention is to keep those in just your name alone and have them pass to a specific person, which does happen from time to time, you can leave those out of the trust and put the beneficiary, but that carries with it the same risks that I mentioned earlier, where if there's some defect with it, the beneficiary dies, whatever else happens, you change account numbers and don't update the beneficiary designation, then you could run into issues with a probate being triggered.
Let's say I did a POD on a bank account, I suffer a stroke. Can my agent under the durable power of attorney change the POD?
It depends on the authority. It's not so much that they change it as much as they will change where the account is held or change the account number. Okay. And that's another thing that defeats these types of designations. And that specifically happens with if you ever have a conservatorship that gets established, is that they actually have to change title entirely to the account. And so whatever designations you had on it are gone.
Co-trustee.
Yeah. If you have co-trustees, that's it's effectively joint ownership because they'd be on title of things.
Is a co-trustee responsible or liable for the acts of the other trustee? If they know about it,
they are.
Okay.
Yeah, to an extent. It's not even just knowing about it. It's almost, if you stick your head in the sand and you're not watching, you're going to be liable for it. Okay. So that's sort of how it's set up, is you can't just be a co-trustee and just ignore everything that's happening around you.
We talked about liability, but we haven't discussed fiduciary liability. What does fiduciary liability mean?
Well, if you are in a fiduciary relationship, which is like what a trustee owes to the beneficiaries, they owe fiduciary duties to beneficiaries. If they breach those duties under whatever the applicable standard is, then they are liable for whatever damages get awarded. That may, in the context of a trust, it's usually referred to as a surcharge. They may be removed, they may be suspended, things like that.
Well, how does that differ from regular liability?
Well, it's much easier to incur liability when acting in these roles than normal. So if I owed no duties to anybody and I was just acting and carrying on my business, there may be some negligence there if I caused harm to someone, but you have affirmative duties when you're in a fiduciary relationship.
Without getting into the specific codes, is the general rule kind of, if I had to summarize, would the best interest, you have to do what's in the best interest of your beneficiaries or in a trust situation?
Yeah, I mean, there are, and that's why I say it's more complicated than that. Effectively, yes, but it also depends on how the distribution scheme is set up. So
Yeah. So can I listen to someone, let's say I have a beneficiary and they said, hey, mom has given me $10,000 a year for the last 5 years. And I can show and I can prove that to you. Can I, as a trustee, continue that payment? It doesn't say anything in the trust that I can do that.
the short answer is possibly. I mean, it's hard to say, right? Because there's more to it. There's other estate planning documents that could influence what can be done, what should be done. The trust terms may also provide that if the trust terms don't say you can, generally you can't, but there are other ways to effectuate certain gifts like that with other estate planning documents.
Yeah, and that's a good attorney answer. It depends. It depends on the totality of the circumstances.
It does, but that's really one of the big issues with probate, trust, and estate administrations is that all of these documents, they're all interrelated, and a lot of attorneys don't get that to an extent because we get issues where people raise things on cases about the wrong documents. They'll want things done that aren't allowed by the specific document, and it's, if you set it up cohesively and properly with an attorney that knows what they're doing, you can mitigate the likelihood that any litigation will arise.
And that's what you want to do.
Yeah.
You don't want litigation. The typical litigation, by the way, is, you could spend easily $100,000 on litigation without batting an eye. Yes, Don.
Since we've moved on to litigation as opposed to bank and brokerage accounts, I'll ask a few questions. Are we going to talk about business ownership, buy-sell agreements, partners living trusts, something like that, or is that not in the slide coming up?
It is in there. I don't know if we will get to it, but there is a slide.
Okay, we got 20 minutes left. So.
Right, and then the other, a couple more questions is under the common ownership thing, like a Laguna Woods or something like that. Same thing exists in terms of UC Irvine, for instance. There's faculty, there's professor housing. Is that the same type of a situation as the stock ownership type situation? Because a professor can't sell their own house. They have to go through the university.
I have no idea.
Okay, that's a delightful answer.
I've never dealt with that issue, but
okay, talk to an attorney.
Sounds a bit more complicated than a stock cooperative.
Yes. If a trustee never administers a trust and doesn't distribute assets, what's the statute of limitations in California?
Whoa.
There is a 3-year statute of limitations for breach of trust, but there are a lot of exceptions to that.
An attorney. It depends. Thank you. Talk to an attorney. A good one.
The short answer is because I have people that come with me from issues 10, 20 years ago. If you wait that long, the problem is no one has records anymore.
Right.
And so if there are no records and the evidence is gone to prove up your case, you probably don't have a great case.
Okay.
So
let's go back to the slide. Can you give someone power of attorney over a trust account?
No, only the trustee is in control of a trust account. Power of attorney or designation of an agent under power of attorney is for accounts in your personal name only.
How about household checking account? Should you keep those in trust?
I generally think that everything should be transferred into the trust. Some people want to keep a personal account in their name. As long as it's a fairly low value, that shouldn't be an issue in triggering a probate.
Yeah.
But that's the risk.
What's that amount that you can have titled in your own name today?
It's 184,500 of personal property and real property. But if there is real property in that number, I believe it's 61,500.
Yeah.
About that. So if you have over those amounts, then if it's in your personal name and not in a trust, it may trigger a probate.
Yes. Let's go to the next slide.
So business interests, if you have interest in a corporation, a sole proprietorship, LLC, or a partnership, the way you transfer those ownerships is different for whatever type it is. If you are operating as a sole proprietorship, that actually becomes much more complicated from an administration standpoint. If you have a corporation, the shares of stock need to be changed to be named as trustee of the trust. If there's an LLC or a partnership, there's assignments of interest, and you want the corporate records, or not the corporate records, but the business records to reflect the ownership change into someone's name as trustee of the trust. So each of the, so for LLCs and corporations and partnerships, all of those, there's specific formalities sometimes that are laid out in terms of how ownership is transferred. If you don't follow those, it may create an issue. Generally speaking, those things are usually, this usually arises more in small business interests, and people usually get along and will do it much more informally and perhaps not the legal way. But it is important. And I always tell people, your partners, it's always great. You guys may get along and do everything that you both want, but you guys may not be the ones dealing with it later. And so it's better to do it formally, because it may be completely different people trying to figure out what you and your partner did 20 years later. And if you didn't do it right, no one may know what happened.
So true. And the thing of it is that if you're the successor trustee of one of these interests, hire an attorney, please, before you make decisions. Let's go to the next slide.
All right. This is just a list of other assets that may be transferred in. Safe deposit box, retitle the names, promissory notes. You can assign the interest.
By the way, promissory notes. How about loans that you made to different children?
So if you've made loans to children and you plan on forgiving them, whatever you plan on doing with it, discuss it with your attorney, because there's different ways of handling it. And I get that. It's actually a fairly common issue. And it really depends on what you want, how you want those loans to be treated when you die. Do you want them forgiven? Do you want an equalizing gift given to the other kids? Do you want that loan still to be paid back? All of those create very different distribution schemes.
Savings bonds.
Savings.
Very rarely see them titled in the name of the trust.
Yeah, and those create issues. We're seeing it less and less, but those can create issues in just administratively, because if you have the original bonds to get rid of them, or to cash them out, I should say, then all it does is complicate the administration should they get lost. If you have copies of them, it may cause more confusion in the administration than anything. So
cars and vessels.
So these can be transferred. These are actually different than the ordinary small estate administration rules. You can title it in the name of the trust. Most people don't. If you're going to title it jointly, it's better to have it as an or than an and, because if you have it titled with a spouse or with a child, for example, and it's an and, then the administratively collecting it becomes a bit more difficult. But the people generally, and it also depends on the value of the vehicle. So
yeah, this is where Auto Club comes in very handy versus a DMV. So mobile homes, completely separate again. Are those considered real property or personal property?
They're personal property, and even that, it's not always the case. But yeah, if it's through there, they have completely different forms. It's all very, very unique forms specifically for that.
Okay.
Speak with an attorney if you do have a mobile home, because it will impact how you can handle that and what you can and what you should do.
How should tangible personal property be? Your couches, your paintings, your jewelry, how should we handle that?
You generally will do a general assignment to the trust, and that will usually cover most assets. You don't need to assign every piece of furniture, every piece of silverware.
What does a general assignment mean? What is that?
A general assignment means that you are transferring it all to your trust or to yourself as trustee of the trust.
So you would have a kind of like a 1-page paragraph or 2 paragraphs stating, hey, I'm assigning all my personal property to the trust, and you sign it and it's notarized, and that is a separate document altogether.
Yeah.
Okay. And that should be with your estate planning documents.
Yep. Okay. Yeah, it's definitely important to keep all of the documents together. because as I said, it's hard for people to figure what you did out unless it's all together, because sometimes they may not even be accessible anymore.
What's a personal property memorandum?
So in your trust, if you can have a provision in there stating that you can that you'll leave a note to the trustee about specific assets to be given to specific people. What this helps avoid is having to go back to an attorney every time you have a change of a beneficiary or some gift of tangible personal property. So it is possible to do it with other types of gifts, but it is more risky. And there's recent cases that came out about it that resulted in mediation and great law for the probate world. But all it did was really complicate these types of issues more. So if you do have it, you just leave a list for the trustee of what property you want. It should be put in a specific format. So speak to an attorney. Like with us, we have a general form set up for people that do trusts with our office that you can use.
And by the way, and if you have like jewelry or you have something very valuable and you wanted to give it to your kids, you may want to give it to them during your lifetime. Would avoid a lot of issues. And if they appreciate it, then you can understand how they will handle the rest of your estate, and you may want to change your estate plan. But personal property is huge in estates.
Yeah, and if you are going to make lifetime gifts, make sure that you document it and that you leave that with your estate planning documents as well. Because if you don't, they're going to just assume that person stole it from you.
Yeah.
So
there's most of the problems occur because of family issues, i.e., hey, growing up, my brother never let me da 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 da, and now they're going to take it out and get even. So you may not be aware of some of the resentments that are there within the family. How do you deal with that, Steve, when you're meeting with a client?
Well, I mean, I raise it to a lot of people, and I explain the issues with it. It's really, if they're going to fight, if you think they're going to fight, they probably will be fighting. And if they're fighting, that means they're probably going to end up in court. It could end up being very litigated. I mean, there's cases in the probate world, unlike most other areas of law, cases go on for years. Some can. Most of them don't, but some can go on for a very long period of time. If you put in a professional fiduciary or a trust company or just some disinterested third party friend that you know, those types of people will have no emotion in it. They aren't going to have the animosity from the beneficiaries, at least at the outset. And that's going to make the administration much smoother. It's also not going to create any power issues between siblings fighting over who's in control.
Yeah, but whoever you name, make sure that they understand the need to hire professionals. Every case, I've been doing this for 30 plus years. I hire legal counsel, I hire CPAs. I don't do this myself, and I know what I'm doing. And as Steve says, I still get into trouble at times. So it is complicated. It's not easy. Our lives aren't that easy. Let's go to the next slide.
So if assets are not in the trust, while you're alive, an agent under a power of attorney can transfer them into the trust. And that's pretty much the only way you can get it into the trust unless you have capacity. Once you pass away, there's three other options. There's a small estate affidavit, which if your assets in your personal name that survive death are below those dollar figure amounts, the $184,500 and the $60,000 for real property, you can get it transferred into the trust, and the trustee collects it through a pour-over will, which is referenced on the other side over there. If a formal probate is needed, that's where the pour-over will come into play, and that will ultimately, through the formal probate process or the informal probate, which is the small estate affidavit, the assets will be transferred into the trust at some point and be distributed pursuant to the terms of the trust. An alternative to those two is if you try to transfer an asset during your life into your trust, or for whatever reason you couldn't or you were unable to, Hegstad and Ukestad petition those are references to two cases. The petition is actually under Probate Code 850. which allows you to file a summary petition to have assets, to get an order determining that assets are titled in the name of the trust and that the trustee has the power to sell those assets. So that saves time. It's expensive, but it's less expensive than a formal probate would be.
And then the pour over will, that means you're going to go through both, a probate and a trust administration. Yes, Don.
In our 8 minutes remaining. So I think there's maybe contention in my estate after I pass away. Can I put in a clause that said, if you take us to court, this thing to court, you're out, you get nothing?
You can, but that doesn't.
Will it survive?
So what you're referring to, it's called a no contest clause, and
Right.
it is something you can put in there, and it's often misunderstood that clause prevents people from doing something. Unfortunately, you cannot prevent anyone from litigating whatever crazy issues they want to litigate. It has to go through the whole court process. What it acts as is a deterrent for people contesting the trust.
Because if they lose, then they're cut out of the trust?
Potentially. So
Okay.
it was stronger years ago, and they changed the law in 2008 or 2009 to really, if someone has what's called probable cause that this document was basically not signed under your own free will,
Right.
And they can prove that, which itself is very difficult to prove. But as long as they have probable cause, the no contest clause doesn't really do a whole lot.
Okay.
It's more, that's a very simplified way of explaining it, but the short answer is you can do it, but it may not really have the intended effect that you're looking to have.
Okay. 6 minutes.
Let's go to the next slide.
So this is the information that you need to set up a trust. A lot of these things people don't necessarily think about. It's best to talk about it all with an attorney, because you'll come up with different issues here, particularly how you want the beneficiary distribution scheme to be, as well as the successor trustees. If you speak to an attorney that it handles more of the litigation side of things, like we do, we'll be able to explain some of the issues with, one, who you're going to put in as trustee, but two, whatever distribution scheme you want. So I don't really know what all the attorneys talk to people about, but if you have complicated legacy trusts and you have a $500,000 estate, probably very little of that is going to go into the actual beneficiaries. If you have $100 million estate, a lot may go, but a lot's also going to go in professional fees and things as well. So the short answer is there's a lot of information that you need, but there's also a lot of things that you won't necessarily think about unless you speak to an attorney about it all.
This is a great slide, and people can take a look at this. By the way, you can get the entire presentation downloaded from iyme.org. Let's go to the next slide.
So gift and estate taxes, right now the exclusion is up to 12 million, and it's doubled for married couples, but that has a sunset date. I think it's the end of 2026. But the estate tax amount can be quite a bit. If you live in other states and die there, they may have very different estate taxes at the state level. California does not, but that's something to be concerned about. And if you do have an estate that's about 5 million or thereabouts, I'd say even 3 or 4 million, you want to speak to an attorney in 2026, or at the very least, pay attention to what laws get passed regarding estate tax, because the law is likely going to change. Whether it gets extended or it reverts back to the previous exemption amount, I don't know. We'll see where the world is in a few years.
Do you prepare 706 returns, Steve?
We do not.
Okay. And what should person expect to pay, or do you know kind of what the cost is for a 706 return?
I don't, off the top of my head, I don't recall.
Yeah, it's around 10,000, somewhere around there. So this is what's called portability. And if you have an estate that's larger than 3 million as a single person, check with an attorney or a CPA to see what you can do. If you have an estate over 12 million, definitely see an attorney. Next slide, please.
Yeah.
I think this is the step up in basis slide. We kind of went through that. So let's go to the next slide. This is we kind of talked about as well, to step up in basis rule. Let's go to the next slide. Marital subtrusts.
Yeah. So marital subtrusts, these do and did have much more application to the estate taxes and estate tax exemption amounts, which they may again in the near future. But presently, for the vast majority of people, most people don't have estates even over 5 million. And so most people that will use subtrusts or have it split into different, have an irrevocable portion will have a blended family. And what that means is you each have kids from prior marriages, or you just have a different idea of how you want assets split. And so this kind of plays into that question earlier about what if you have an uncooperative spouse? Well, if you guys have completely different ideas of how you want things distributed, you can utilize subtrusts. And so when one of you dies, you lock in your distribution scheme with your assets upon your death, so that the survivor can't change it. And there's risks with that as well, and costs, but that is the easiest way of going about that, or doing a separate trust entirely.
So for married couples today, because AB trust was very popular 10, 15 years ago, should you change that, or should you see an attorney if you have an AB trust today?
You should, yeah, because you may not need it, but what I often run into with people that have a spouse pass away is they have a trust that requires them to do things, and they just don't do it, or they don't want to because it's expensive. It can cost somewhere between 5,000 and 10,000 depending on your assets. If you don't do it, you run the risk of litigation later, and that's much more likely if you have a blended family with children of the predeceased spouse.
Yeah, you keep it simple, stupid, as they see. Don, you reminded me of that
every time. Jeez, Pete, I thought we were friends. Okay, I'm going to ask a question, and basically, Steve, go to your last slide if it says your contact information. And they can download all of these, so that's fine. But I just thought let's at least try to get you a whoop. Nope, that's one back. I don't know. There you go. Okay. So we do have one question, and it comes up frequently, and that's why I wanted to make sure we covered it in the last few minutes that we have.
Yeah.
Why don't you go ahead?
I have a kid that I want to exclude from the will. What?
Do you want to go ahead and put us all on the screen there?
Not yet. I want to let people write down Steve's contact information. Then I'll tell him to take it off.
Okay. All righty.
I have a kid that I want to take off of my estate. Can I exclude them?
You can.
What should I do about it?
Well, you can. That's where the no contest clause will come into play a little bit.
Okay.
You have to have some sort of a document saying they're excluded. So that's
right. I was going to say you can't just ignore them and say pay everybody else, but not this one, or they can claim they were just forgotten. So you have to say I specifically exclude them, except I'm going to give them $100. Yeah.
You don't have to leave them in it. You don't even have to leave them $100. Okay. But what often happens, and so everyone's always concerned about someone contesting the trust. It's actually fairly unlikely that will happen. Usually when people are being cut out or excluded, they will be well aware of why, and they will have no interest in pursuing it.
Right.
But yeah, you want to set it up in a way that I always try to put some sort of an explanation, at the very least in my own personal notes here, as to why this was happening. And some people don't want to tell their attorney because it's personal family stuff. That's where the attorney-client privilege is great. It will only come out if there's a dispute after your death. But generally, it's very helpful for the attorneys to understand why you're doing it.
Yes.
Okay. And Steve, now why don't you stop sharing your screen?
I think the whole estate planning area is becoming more what's best for my family. It's not tax driven for most estates. It's, how can you need to talk about your family to the attorney. Are individuals reluctant to do that?
Some are. Generally, some people are want to share everything.
Yeah.
Which is it's helpful to understand your family dynamics. So I mean, and that's part of what kind of I think at least has changed from 30, 40 years ago, is all of this is intended to be private. But I tell people, yeah, you have rights of privacy, but you're gonna cause ill will and bad feelings if you don't explain why you're doing something to your family. I could tell them why you did it all I want. Well, within reason, within the law for the privilege, right? Or you could, Pete, explaining why someone left something. But unless they hear it from you, they don't understand why this happened. And they may not necessarily even believe you if you were trying to explain it to them. That's the problem.
And the documents that you describe are very legalese. There's no I love you in these documents. And so leaving a letter to your heirs, an I love you letter, sometimes smooths over a lot of difficulties.
Yes.
And so I know, Don, we're at the end of
right there. So
we're right there.
Steve, thank you very much. This is It's Your Estate, Wills and Trusts. The common thread through this whole thing is it depends. Which is a very valid thing and a very good reason, but this is not always a simple thing. And I want to point out one thing, and Pete and I occasionally raise on this. We talk about all these disasters that are occurring. And the vast majority of estates settle with no problem. Everybody's friends, everybody's great, things go on, but they don't always. And therefore, make sure you document it correctly. And the better you document it, the better your chance of having it go through easily. And so that's where it's really important. This has all been recorded. I can look up here and it still says it's recording.